Hello, welcome to a special feature of the Launchpad, a student-led career exploration series mentored by our career counselors. In each edition, we explore different careers through student-led and real-world experiences. This edition is all about law.
As a part of the journey, we got to learn about mock trial and moot court, which are two different formats where people got to understand about the legal system. Moot court, students take up points about law and debate in front of the judges, whereas a mock trial, they play out an entire courtroom case with witness, prosecution, defense, and a verdict.
These formats are signature events at top institutions, from NLUs in India to Harvard and Oxford. They help the students to think, reason, and speak like real lawyers. But first, a prelude. We begin with a Moot Court Workshop, led by our alumna lawyer, Dhisha, who introduced us to how real legal arguments are made. That became a foundation for the mock trial ahead. Let us take a look at how it all began.
Next page, please. Let's start with your team formation. See, usually there are 3 members in a team for a moot court competition or mock trial. In special circumstances, say we do not have enough people, then we can have 2 people in a team. But usually it is 3, and it is advisable that you have this 3-person team because 2 people will be speakers and 1 will be a researcher. Now, the speakers will divide the issues among themselves while speaking. It can be equal or however you want. That is at your discretion. How you divide those issues, that is your wish. But the researcher's main work is to research and write the memo and find any fault in the opposing counsel's memo. And also they have a very active role during the oral round as well. Because say the opposite person has made a mistake in their argument. It is the researcher's job to find that and write the proper rebuttal for it. As well, see if one of your speaker or your teammate is struggling to answer a question or has forgotten a point, the researcher can write that point in a small paper and pass it as a check. So that is allowed. That is the work of the researcher. And usually in national moot courts, this researcher sits in for a final researcher's test. After your written submissions, your oral rounds, there is something called the researcher's test that they would sit in, and whoever scores the highest mark would be given the best researcher. But right now, since you guys are just beginning, you will not be having that. But just remember, that is the role of the researcher here. And researchers will also be allowed to speak. Don't get me wrong. In case one of the speaker is unavailable or they're not able to speak, then they'll be called upon. Next slide, please. Okay, rounds. Obviously, you have your written rounds, oral rounds, your finals, and your researcher's test. Initially, the beginning, what you'll receive is you'll receive the moot problems with a set of rules, and you'll receive your team code. Okay. Now, once you read this moot problem, usually they'll give you the issues, but in national moot courts or international moot courts, they will not give you the issue. It is up to us to form the issue. But since you guys are just beginning, along with your moot problem, you will be receiving the issues as well, and it is enough to address those issues. I'll explain them in detail. So once you have gone through that, you'll write what exactly is the fact of the case, what are the issues, what are your arguments about it, and how you are defending or how you are approaching that issue will be written in that memorial. Only what is there in the memorial can be presented in the oral round. Okay, you cannot omit something here and try to include it later in the oral round. That will not be allowed. Yes, can we move on to the next slide? Okay, so we'll talk about this written submission later because I was told that you guys will not be required to do this. We'll directly move on to the oral round. Still, I'll tell you guys about how to write and everything in detail. I'll tell it later. Okay, so normally in an oral round, we have obviously 2 preliminary, semifinals, and finals. Usually for your preliminary rounds, you'll be given 25 minutes and you can ask for a grace period of up to 5 minutes, but it is advisable that you stick to the time period only. And for your semifinals, 35 minutes, and for your finals, they'll give you 45 minutes. Can we move on to the next slide, please? Okay, so first, I told you you'll receive the moot problem with issues. How can you deal with these issues? How to read them first? See, reread it, read it 2 times, 3 times, or how many ever times it requires for you guys to be properly well versed within the facts of the case. And then the issues. Okay, see, issues are the question just what you have to address. Now you have the facts of the case. What is the problem? What are you asking for? What are you trying to address? So now those are issues. How to read the facts of the case, I'll tell you. First, you make all the timeline, the important dates with the names of the witness, names of the petitioner and the defendant, and a chronological timeline of what has happened. Then make a flowchart. And one thing that I used to do personally, so I used to take a paper and I'll divide it into two sections, like whatever points that are in favor of me and the points that are against me. Now, all the points that are in favor of you will emphasize on those points because that is what will make your case, right? That is your plus point. So you will find legal principles and precedences and you will argue very strongly for that. And in the column that says against you, what are all the points that are not for you? Now you have to be very careful because that is what your opposing team will be emphasizing on. So you already know what their point of view is going to be. What are all the points that they're going to throw at you? So you can prepare for your rebuttal in advance. So that is what everybody does. You have to address all of these issues. Like you cannot omit anything from the facts of the case. You cannot add something of your own or anything like that. Can you move to the next slide? Okay. Now you've read the case. Now you finally understood the facts and everything. What can you do? How can you do the research? First of all, you have to understand which area of law that particular province falls under. Criminal law, civil law, environmental law, constitutional law, anything like that, under which area of law it falls under. First, you identify that. Next, what you'll do, you'll identify the legal provisions. That is, example, like which section this particular fault is coming under. Like this particular offense is under which act. So once you get that and you get those legal principles, you'll move on to precedents. That is your previous case laws that has been decided by the Supreme Court or the High Court. You can get previous judgments from Supreme Court and High Court, but I suggest you stick with Supreme Court for now because that Supreme Court judgment will overrule all of the High Court's judgments. So it has a better precedent. So you stick with Supreme Court judgments. Okay. Can you move on to the next slide? Okay. Where can you research? I've given a few research websites here. Bar Act is for your sections. It'll just have that law and its statutory provisions alone. Otherwise, you'll not find anything else in a Bar Act. But these other websites like Manupatra, Westlaw and everything, it is for your previous judgment. I strongly suggest you use SEC online because that, I'll tell you what, it is a paid platform, but don't worry about it. They have a free trial period. So I suggest you try to subscribe and get that free trial period and complete your research within that given time and unsubscribe. So you don't have to pay any money for it. You have a lot of free websites as well, but they do not have keyword search. So you'll have to end up manually researching all of these problems and it can get very overwhelming because usually judgment sometimes will contain hundreds of pages as well. You will not know where to look. So it is better you try this website. One thing that is very good here is the keyword search. Like you just put in the section and certain keywords, say criminal law, theft, something like that. A keyword you put in and all the judgments of the Supreme Court that has these keywords will be given to you. And now only all you have to do is read those judgments and link which one is more suitable for you. Okay. Can we move on to the next? Okay. Now I told you what issues are. Like you know the facts. What are you talking about? What is your argument about is issues. See, there are two types of issues. Okay. There are many types of issues. So basically two. There is issue of facts and issue of law. Issue of facts is like the questions from your fact, like what was the damage or when something happened or who did it. Issue of law is a question of whether, okay, see whether this amounts to theft or whether the lower court had jurisdiction on doing so. And on giving such judgment, did they have jurisdiction? All of that, whether the question of a legal question is an issue of law. Apart from that, you have issue of jurisdiction, you have issue of timeline, like whether the limitation has passed for it, but it is a little too intense. You learn about all of that once in college, but for your competition, I think these two kinds of issues will be much easier, issue of fact and issue of law. Can we move on to the next? Right, for oral rounds, you'll have your team code. 3 people in a team, I told you. One will be for the petitioner and the other for the defendant. And now you will have 25 minutes each. First, the speaker 1 will talk. The structure is that you'll talk about facts of the case, then you'll talk about the issues, then you'll put forth your arguments, and then finally you'll conclude. And after the second speaker talks about again their second issue and their arguments, and finally a prayer. Can you move on to the next slide? First, how you start is you come in and you tell who you're representing. Okay, your team so and so. You're representing the plaintiff in the case of, say, People versus Crenel or something like that. That is the name of the case. And you'll say that we are representing the defendant or the petitioner in this case. And this case falls under this particular section of criminal law or constitutional law, something like that. And then you'll move on to the facts and everything I told. Facts, issues, arguments, finally the prayer. One thing that you have to remember is before you start saying the facts of the case, you need to ask permission from the judges. Like, Your Lordship, can I recite the facts of the case? So between each transition that you make, you have to ask their permission. Like, you're moving from facts of the case, you're done. You want to move on to listing the issues. Then you'll have to ask permission. Your Lordship, may I move on to the issues? After that, Your Lordships, can I move on to the arguments? Okay. Like this, you'll be asking questions for each round you transition to. But when you start with your argument, it is important to note that not only in your moot court, even when you actually practice in high courts and local courts, your language should be very humble and formal as well. You cannot say, Your Lordships, we argue for this point. Try to avoid those words and instead use submit. Your Lordship, we humbly submit or we respectfully submit in front of the bench. You can put on your arguments. Okay. But then finally, whatever point you have talked about your entire speech, try to conclude it in 1 to 2 minutes. Like finally 1 or 2 points, what are you trying to say? It should be clear for you. And since I told you the whole introduction, your fact, and your listing of the issues, if the judge is permitted, should be completed within 1 to 2 minutes of your entire speech. You cannot drag that. Your main focus should be on how you structure your arguments, how well you have researched, how well you have understood it, and how well you have taken the statutory provisions and the case laws and all of that. That is very important. Let me move on to the next. Okay, how to address the judges. See, usually if there is more than one judge, you call them bench. And I suppose you'll be having more than one judge, or else you'll call them counsel. I've given like a certain words for international moot court and national moot courts, and there is difference. For tribunal, we address them differently. Bench or your excellency or excellencies, lordship, ladyship, or my lord, any of that is okay. And it is important, like once they ask you something or you ask them something and they give you a reply, instead of saying okay, you have to say much obliged. That is very important. So for example, Your Lordship, can I recite the facts of the case, like I told you? And they say, okay, fine. You say much obliged, Your Lordship, and then you continue with it. Okay, instead of saying okay, we say much obliged. Other than that, certain rules that you have to follow is when your team is giving the prayer. I'll tell you what a prayer is in detail, don't worry. When they are telling the prayer, your entire team should stand up. It is like a form of respect that you show. And one thing, you cannot talk among yourselves once the competition has started. You can pass on notes and chits among yourselves. That is fine, but you cannot talk. And you have to be very, very patient when a judge asks you a question. Sometimes, they'll keep asking the same question like over and over again. Even though you've answered it multiple times, they'll be very stubborn in their point. Sometimes it can get very irritating. But you have to remember that they're probably testing you for how calm and spontaneous you are. So as long as you remain calm, first, do not interrupt them at all. Let them completely ask their question. And then, see, you cannot say, even if you disagree with their point, you cannot say, no, I disagree with that point. You cannot do that. You have to agree. Indeed, you can say, indeed, Your Lordship, but my point is, and then you can keep your point. So that is how you talk to them. You have to be very respectful. And your language should be very humble and very formal as well. Is that it? Yes, that is it. Can we talk about, go to the PDF section? Okay. So here you see, here this particular memorial, here they have filed it in front of the district court. This is how, if you are writing a written submission, this is how your front page would look like. In the matter of the name of the plaintiff and then the defendant, And a memorial, see, this is a memorial from the petitioner side. If you are representing the defendant, then it will say memorial for the defendant. But most of it, the front page would look more or less the same. Okay. Next, you'll have your table of, move on to the next page, please. You'll have your table of content. Okay, move on to the next page, please. Yes. So the list of abbreviations. Whatever abbreviations you guys have used inside the memorial, all of that has to be listed out front. See, SC means Supreme Court, HC means High Court, stuff like that. You'll get it once you start going with it. But these are the list of abbreviations. Whatever you use, you'll have to put it here. And then your index, like index of cases, what are the statutes that you have done, and what are the books that you referred, what are the websites that you referred. All of that needs to be mentioned in the beginning itself. Yeah, after that you just see statement of jurisdiction. It is important when you do a moot court in your college, but as of now I don't like it is important you guys understand about jurisdiction and everything, so let's skip that part. The statement of facts has already been given to you by the competition board. Now how you have to write it here and how you have to present it in the oral round, not, and you cannot dictate what they have given you. Like you have to tell it in a convincing way from your point of view. If you are the petitioner or the defendant, you tell that fact in a light that makes you look in the correct way. Okay, from your point of view, you will be rewording those facts. We move on to the next. So these are the issues. I already told you, for you guys, you'll be receiving the issues. And then your summary of arguments. The summary of arguments. So for issue 1, what is your argument for issue 1? All right, like move on to the next page. It's just a summary. Okay. For that issue, what is your agreement? What are the case laws that you are citing? Which legal which provision is talking about that particular violation? So all of that, all of your detailed argument section will be here. And only the points that are in here, you can talk in your oral round, as I said before. Okay. Please move on to the last page. So that is how this entire argument will be, like for issue 1, issue 2, issue 3, whatever it is, prayer. Prayer is nothing but what are you requesting the court? You know the facts, you have made your argument, fine. What do you want the court to do for you? That is what the prayer is. So this is the format of the prayer. You can see, if you guys want it, please ask them to share the PPT and the PDF as well, so you can use it as a reference. But this is how a prayer will look like. That is, you're basically asking the honorable court, like, in light of all of these arguments, please consider this compensation for us. Please award us this compensation. Basically that is what a prayer is. Okay. That is it with the PDF. One thing I wanted to add, if you guys get a criminal case for a mock trial, I suggest that you make your friends pretend to be witnesses. We used to do that. It was so much fun, actually. Like, you tell them the facts of the case. I'll give you an example of a case, and from there I can go on. See, say a person has been arrested for a theft of a rare book from a public library. Let's call him Mark. He has been arrested. He went to an unauthorized archive section of the library. Say he stole that book, and that book was found in the trunk of his car. But the problem is, that particular person says he had verbal confirmation from the librarian to go and retrieve that book, to get that book. So that is why he went and took it, but he did not take it home. And for the question of why it was in the trunk, he is claiming that someone put it there to frame him. As of evidence, there is a CCTV footage of him entering the unauthorized area, but there is no audio or no actual footage of him taking that book outside. So now how you will approach this case? So the issue is whether under section 303 of the Bharatiya Nyaya Samhita, whether this amounts to theft, whether he is guilty of theft. That will be your issue. What law it comes under? Criminal law. What is the legal provision? Again, 303 Bharatiya Nyaya Samhita, it talks about theft. Okay, for precedence, there is a case. This case says, even though it is very clear that these coincidences, that these instances meant that he had an intention to steal it, but there is no concrete or proper evidence beyond reasonable doubt. So because we do not have anything more than just doubt that he took it, we cannot convict him of the crime. Okay, so that will be your judgment. But how can you approach it in your moot court problem? If you are the prosecutor side, you can call the librarian as your witness. You can ask one of your friends to pretend to be the librarian. You can give her the facts. See, you were working on this day, and you saw this person, he came, you have to tell him that when asked, you will have to tell that you did not give permission, something like that. Okay, so you can examine them. Your opposing counsel can cross-examine them, asking them questions like in an actual trial. And then you can put this, accused also in the stand, and you can ask him questions and cross-examine. That would make it more interesting, in my opinion, because instead of just talking, it would be like an actual courtroom experience for you guys. So that is something I strongly suggest.
So that was a prelude. We hope you enjoyed getting a behind the scenes look of how we have been preparing to enter the field of law.
From understanding the legal arguments to stepping into the shoes of lawyers and witnesses, it's all been building up to one moment. Law Summit right here this August in our school.
It's going to be a powerful student-led courtroom experience. We invite all students to come and witness it live. You won't want to miss it.